you ever been part of a team or a partnership breakup? How about just when personalities and the human condition just make your day-to-day miserable? Well, I've seen this situation many times among teams. I've also lived it, sorry to say, but it's one reason that I'm so delighted to be hosting today's Arcview Access program. Hey, I love the title, don't you? It's not you, it's me. Oh, wait a minute, it's actually you. I've seen many young teams and teams that are not so young not even document the partnership or the relationship, the team arrangement. Like, what is that? No wonder they end up in litigation. I am Jean Sullivan. I'm part of the Arcview team, and I'm a longtime venture capital investor with more than 25 years of experience dealing with many young entrepreneurial teams and growth stage companies. I have seen a lot of misery and breakups along the way. First, a quick note about the Arcview Group. I am so proud that as a vast community, we have invested more than $300 million in just about every cannabis company that exists. But now, guess what? We have set up several subsidiaries to serve new investors and many of the well-known current investors, entrepreneurs, both new and former, building new companies. We have Arcview Capital, which is a FINRA-based registered broker-dealer, as well as a crowdfunding platform, pretty interesting. Arcview Ventures, of which I'm a co-founder of the Collective Fund with my business partner, Jeff Finkel. We've invested already in 19 companies. We want to hear from you if you have a company that we should review. And Arcview Consulting, doing some really great things. Do you need a license? Are you in license pursuit? Serving both young companies and multi-billion-dollar companies, figuring out strategic plans. Listen, in case you didn't know, the Northeast is really hot and exciting with all kinds of new opportunities for licenses. So they're very active with that. So also excited to say that we've announced the Arcview Events and Experience Team, a joint venture with McVeigh Global Marketing, a great group, seasoned pros on doing events, both in person and digital. So that's been fun to collaborate and put that together. I am so proud to tell you that since COVID, we have put on more than 90 digital programming efforts. So it's been a big lift, but so interesting. And in our 12-year history, more than 40 in-person events. So, stay close to us as you can join us. Now, just a sneak mention of which I have no authorization to say, but we are putting together our first post-COVID live event. It's this fall, so watch for your save the date. It will be in fabulous New York City, where I live. We have a survey for you because we like to know what's important to you. So Erica, go ahead and put that up so that people can, yes, fill that out either now or push it to the side and do it later. This helps us with programming. Now, before we kick off our really interesting conversation today, I want to thank our alliance partners because they help us pull these together. They provide great resources and we commend them to your usefulness. Listen, if you need a bank or banking services, PayQuick can give you all kinds of treasury services. We have law firms, Ice Miller, Dwayne Morris, and Zuber Law, the host of today's session. We've got insurance company, Alpha Root. You need seed to sale software, GrowFlow, really interesting. Payroll services, that's Work. And some really interesting financial services partners, Waterton Partners, Northstar Financial Consulting. And we also have Green Growth CPA. So there's some really terrific support. These teams work across the country, really interesting. Now, today, as said, our host is Zuber Lawler. Zuber is a really interesting firm with a lot of reach across the US and a lot of experience in the cannabis industry and on our very subject today. So Jeff, talk to us on how to avoid misery, create high performance teams, what to avoid, what to think about as you put teams together. And with Jeff, our special guests, Bruce Langstaff, Janet Jacob, and Mike Kesky, who are all strong, experienced thought leaders. Jeff, over to you. Take it away.
Thank you, Jean. Hello, I'm Jeff Zuber. I'm founder of Zuber Lawler, one of the most selected law firms in the United States, which represents clients throughout the world from offices throughout the country. I'm based in Los Angeles. Zuber Lawler has represented leading plant medicine companies since 2006 and practices at the cutting edge of law in industries such as blockchain, cannabis, and the emerging market of psychedelics. Zuber Lawler is uniquely situated to manage plant medicine IPOs, M&A and other deals, intellectual property, FDA and other regulatory work and litigation. The firm's attorney roster includes bioscience PhDs and engineers, literal formal rocket scientists, so we understand the science as well as the business of plant medicine and cannabis. I'm also a founder of the magazine Psychedelia and the psychedelics industry's leading magazine. We're partners with Microdose in this endeavor, who put on Wonderland, the industry leading annual psychedelics conference. As Jean said, our panel is It's Not You, It's Me. No, it's actually you. How to avoid partnership breakups. So we're here to discuss in general ownership disputes. Things that are never going to happen to you, but of course, they probably will if you do this long enough. In the words of the famous English poet Alexander Pope, the jealous God, when we profane his fires, those restless passion in revenge inspires, and bids them make mistaken mortals groan, who seek in love for aught but love alone. And what Mr. Pope was saying way back in 1717, he was giving us a warning. For those of us who seek to enter into a relationship, in his case, romance, that love is a package deal. It comes with a lot of baggage. It's not all upside. And those of us going into business who think that it's all going to be glory and unlimited profits will be groaning when the hard times hit. Those that prepare themselves professionally and enthusiastically will be best able to weather the storms, and there will be storms. And now that the English literature portion of the event can be checked off, let's get into substance. Allow me to introduce the panel. First is Janet Jacob from our law firm, Zuber Lawler. Janet is named one of the best lawyers in America, is an experienced leader for all kinds of matters related to the cannabis industry. She handled the acquisition of cannabis operations across the nation and represented clients in relation to cannabis dispensary certificate applications, buyout transactions, business restructuring, and partner dispute resolution. Ms. Jacob's clients include multi-state operators, dispensaries, producers, cultivators, investors, lenders, landlords, tenants, and vendors. She serves on the board of directors of Arizona Cannabis Chamber of Commerce and in leadership roles on other notable cannabis-related organizations. Janet obtained her JD cum laude from Loyola University Chicago School of Law and her BA with honors from Indiana University. Hello, Janet.
Thank you. Thanks for that kind introduction. I appreciate it.
And next, we have Bruce Langstaff. Bruce is a seasoned capital markets professional with robust primary research and valuation skills. He's a trusted advisor to institutional investors, financial institutions, family offices, and corporations. He helps investors and issuers solve business problems that touch the capital market. Often these problems arise around a corporate event like a sale or a bankruptcy. Mr. Langstaff sees a lot of situations where deficiencies in operating agreements, governance agreements, and other organizing documents create problems down the line. Hello, Bruce. And next is Mike Kesky. Mike is the general counsel for Item 9 Labs Corporation, a publicly traded, vertically integrated cannabis franchisor and operator. Item 9's Unity Road brand is the first national cannabis dispensary franchisor in the United States, with more than 20 partners developing the brand across 9 states. Unity Road provides a solution for industry newcomers and small, locally owned and operated dispensaries to compliantly thrive thanks to the backing of a national franchise. Mike is the top legal and human resources officer for Item 9 Labs, and before joining the company, he was a lawyer at the New York offices of the international law firm Skadden Arps. Hello, Mike.
Hey, Jeff. Thanks, everybody.
And thank you all for joining us. Let's jump in. Janet, my first question is for you. When a client asks for assistance in drafting a partnership, what kind of advice do you give?
That's an easy one to answer, but I'll take a stab at making it short and sweet. I think the first thing that needs to be done is that your client needs to conduct due diligence. Yes, Big Brother is watching. I think you want to know what your prospective partner has been doing all these years. Get a resume from him or her. I think you want to confirm those credentials. And I think you go to Google, for example, to take a look at what information is in the public realm. LinkedIn, Facebook, Twitter, those are all great opportunities. You can even go further and go looking for lawsuits in your local jurisdiction. Check your county clerk's office. Look for employee complaints on glassdoor.com. Look for trademark and UCC, Uniform Commercial Code filings. Those indicate whether there are loans outstanding. Look in the US Edgar system. You want to find out basically from the federal government, the SEC, whether there's any publicly disseminated information on a publicly traded stock company. And I think if you're talking about an investing partner, you really need to know whether your partner has the proof of funds to show the expected investment. I recently got involved in this kind of due diligence and frankly didn't expect to find a lot. What happened was that a cultivator from Colorado was moving into Arizona, wanting to establish a presence, and a broker who was looking for licensees made a couple of recommendations. Well, on the first recommendation, I found that the family operating the dispensary was fighting. It was actually in several lawsuits. Parents were suing their children, alleging that the children had stolen the dispensary license from them. So that's a great opportunity to say to the client, I don't recommend that you proceed. I want you to know what's here and you make the ultimate decision. Fortunately, I think this client made the right decision by walking away. So that's one point. I can tell you more if you'd like.
I would. In terms of the family dispute, I'm on the parent side. Children are notoriously ingrates. So that's where I stand. Yes, well, let's switch it over to Bruce here on a related note. Hello, Bruce. My question for you, why do these types of ownership and partner disputes seem to be endemic to the cannabis industry?
I think there's a couple of reasons for that. I think that there are a number of folks in the cannabis industry who have how do I say this diplomatically? There are a number of folks in the cannabis industry who are tremendous advocates for the product. They're extraordinarily knowledgeable, but it doesn't seem to be an industry that has historically attracted a lot of people with classical training in business. As states have liberalized their marijuana laws, there's been this land race mentality to be first to get a license, to be first to be in business, and that has given rise to an environment where a lot of people have said, "Look, we've got to be in the market now, and we'll paper everything later." And if I can give the the people in attendance today, one piece of advice, it's paper everything first. It might take a little bit longer. It might cost a little bit more money, but the IRR on the money that you spend doing it properly at the outset is really quite critical.
And you raised at least two important points there. One, that there may be a culture issue in terms of the industry, but also there's also sometimes it's a funding issue. Sometimes it's not that people don't care. It's just that you have a certain amount of limited resources and you can allocate them, and it only goes so far. So that's an important point. And I started off with that little poem excerpt, but and because I am a cornball, no question about that. But it is so very important to overcome that cultural issue and that feel good upside at the beginning of a relationship that things are going to work out, and that these risks are worth it. And you and Jen are so right. You got to take care of these things beforehand. And a lot of companies don't have the funds to hire a GC, which brings us to our next panelist, Mike Kesky, again, GC of Item 9 Labs. When they do, often they are overwhelmed with issues, with business issues. And even when they can afford a lawyer, it's one lawyer that has a certain skill set. And the number of issues facing companies are just, it can be overwhelming. And so I actually think, Mike, you have the most stressful job in America, the GC of a young cannabis company. But my question to you, Mike, is what are the most common mistakes two parties can make that can lead to these ownership disputes?
Yeah, thanks, Jeff. And you think I have the most stressful job. I would say that the most stressful job in America would be outside counsel for a young cannabis company. So I would think that you might have the most stressful job of anybody. But yeah, I think that this is the right question, and this is kind of what we're all here thinking about. And I think it's helpful to maybe think about the cannabis industry as a whole, right? It's an industry that's kind of in its infancy. Companies are just kind of starting out. Some of the stuff that Bruce had talked about, a little bit less of the traditional business experience. And I think that all that kind of piles on to create a little bit of pressure on cannabis companies to move as quickly as they possibly can. I've had conversations in the past with potential deal partners who expected us to be able to go from the signing of an LOI for a multi-million-dollar transaction to the closing of the transaction within the same week. You can imagine what their faces looked like when I told them it's probably going to take several months. But it's just kind of one of those things that people are under a lot of pressure to move. You always have to be first. And I think that that's one of the values of having counsel, whether it's in-house counsel or outside counsel, is that you have somebody there that's kind of thinking about the best way to do any transaction that you're thinking about entering into, and somebody that's going to be thinking about the timing and the things that you might be overlooking that would lead to headaches in the future. Another thing I think you run into a lot in cannabis, and Bruce, you pretty much touched on everything, was that some people just don't really want to write everything down. And I think that this comes up a lot dealing with smaller companies, startups that may not have the luxury of having a robust legal team or a robust team in an outside counsel setting to kind of help them through these things. But these companies sometimes view a lot of transaction formalities, negotiating specific provisions and specific sentences of agreements, finalizing inventory lists, these kind of things. They view them sometimes as unnecessary delays. And being able to have counsel that kind of understand that these things are necessary and we're doing these things for a reason to make sure that both parties are staying protected and both companies are protecting their rights at every stage. It's okay to move a little bit more slowly on a transaction if you're moving slowly with the purpose of doing it the right way. And it may not always be the answer that people want to hear from their lawyer in-house or outside, but avoiding any potential future disputes because you took a little bit extra time on the front end to button everything up will end up being worth it for the company.
That's why in-house counsel, otherwise known as Captain Buzzkill to the business people for your organizations. There's always that constant tension, move fast, get things done. And we need to make money versus making sure that you minimize the risk. And those things often create a tension between the executives of the company.
Exactly.
If I might add something here, I think that the cannabis industry has an additional couple of risks that makes people to be overly sensitive, anxious, tenuous. You know, they're looking at the fact that we have this disjoint between states and the state laws on cannabis and the feds. And of course, the federal government has indicated that cannabis possession and use is illegal. So if the operator obtains a license, that operator has spent a hell of a lot of money in some cases to get there, to have that license. And when you impose licensing requirements upon an operation, the management and ownership of the company become quite concerned about whether there's any possibility that the license will be lost. Well, many of the owners in this industry of cannabis licenses and their management people are operating as best they can, but unfortunately, if they can't comply with laws, they run the risk of losing the license. So in many communities across the country, we're talking about investments of 20, 30, $50 million in getting a license. Well, if that isn't anxiety causing, if that doesn't cause a rift among the owners in a newly formed entity, in a relatively newly formed industry, I don't know what does. So I think these kinds of special issues in cannabis put greater issues on the face, the thoughts, the brains, the just very everyday activities of the owners and managers, thereby causing a lot of rifts, a lot of disputes.
Thanks, Janet. And my next question is for you.
Oh,
When a client calls or emails you on the eve of an imminent partnership dispute or breakup, what steps work best to minimize or resolve the dispute or breakup at that early stage?
well, of course, the first thing is to make sure that the contracts are appropriate. I like to include, particularly in cannabis contracts, I like to include a provision for an immediate mediation, which is informal. It's an attempt to bring a third party in to talk to the parties about their dispute. And so before you get to a dispute stage, I like to see that kind of protection in the agreement. This kind of mediation would involve, say, a local leader in the community, or it might be an attorney with cannabis knowledge who can be available immediately, over the phone, in person, by Zoom, whatever, to try to get the parties to resolve the dispute. If that's not in the agreement, then the first thing I think lawyers need to do is figure out who represents whom. Because, pardon me, if there's an entity involved, some lawyer needs to represent the entity. If there are partners, maybe there's, say, 2 or 3 partners, then there could be 2 or 3 attorneys representing them. If there's a board, if there are managers, again, other attorneys need to be representing them. And so you get a cast of thousands, unfortunately, immediately involved. And that group of people need to sit down and talk first before anyone takes any additional action. I mean, I could go on with mediation and arbitration.
No,
I don't want to be a hog here.
I am a big believer in mediation, Janet, and I'm glad you brought that up. And that is a crucial thing to bring on in the early start part of the stage. There are certain settlement points in every case where it makes sense to really focus on settlement with the other side. A lot of people, a lot of executives are hesitant when you suggest mediation to them and proposing it to the other side, that it shows weakness. And among seasoned litigators, it does not. If you have a lawyer advising you that to suggest mediation shows weakness, you've got to check that lawyer for a diaper, because that lawyer has not been around. And And it's usually, in my experience anyway, the party most likely to propose mediation is a party in a position of strength, a party that has just won, for instance, a crucial motion. Usually the party that lost will not suggest mediation. It will be the party that won saying, are you ready to say uncle? It's actually a move of strength to suggest, and one of the lines that I will say is, let's get a mediator to talk some sense into our clients. And by our clients, I mean, your stubborn, dumb client is what I mean. But everyone knows what that means. But mediators, if you get a good mediator, it can go a long way. And sometimes even when you don't resolve it in the mediation, the seeds for the resolution are planted during that exchange. So it can be very important, and you should not shy away from it. Although it's looked at sometimes as an unnecessary expense, compared to the overall cost of litigating a contentious case, especially when there's no documents, the cost of mediation is extremely low. And again, it may bear fruit down the line, even if right now the case may appear unresolvable. So mediation crucial.
Hey, Jeff, let me ask you a question along those lines. Can you give our audience an idea of the cost of litigating in terms of attorney's fees? I mean, can you give them some ranges?
Well, for our firm to take a case in general, and there's always special circumstances, and you have to make sure you talk with your client, you understand expectations, and you let them know the upsides and the risks involved. But for us to comfortably come on for a litigation, usually we want at least several $100,000 at stake. And sometimes there's injunctive relief. There's some assets involved. There's IP involved, and you have to go in regardless of the amount of money that's currently at stake today. But usually you're looking at that. If you have a much smaller dispute, you may want to go to a solo practitioner who will handle the things much more efficiently. And those types of litigations, they can run them very good and very competently, but they're not talking to everybody. They're not deposing everybody. They're not looking under every rock. But for hard fought litigations, Janet, as you know, they go into the millions for business disputes. And part of it is out of the control of any one party. And sometimes you can have both parties that want to do things efficiently, and that can happen. But whenever you get one party that's got the scorched earth policy towards litigation, it's going to drive up those costs. In fact, some firms and some litigators and some companies do make a concerted effort to gain that reputation that if you get into a dispute with us, it is going to cost you a lot of money because we will not settle until the absolute last moment. So you are going to have to spend this money just to figure out what your case looks like before trial. And this is a well-known strategy, and it's employed by a lot of companies and a lot of law firms. So it is expensive and it is daunting to think about. Okay, I'm moving on. My next question is for you, Bruce.
Sure.
What steps should be taken to establish ownership and governance matters at the initiation of a business relationship?
Look, I think the first thing is that you have to decide what's right for the partners in terms of how you're going to organize the business. Okay, and in most cases in the States, an LLC is the right thing, but you should also consider whether an S corp or a C corp is appropriate. Then it basically just comes down to writing every single thing down, right? One of the issues that I've seen in the very recent past is a situation where a number of people got together, they started an LLC, and various partners contributed various things in kind, right? One person contributed, they had what they thought was a below market lease on a location, and one person put in money, and one person put in intellectual property. And there was nothing in writing about how any of that was valued at the outset. And then when a dispute arose, the person who had contributed the below market lease said, well, wait a minute, I never said that this was worth the same as that. I just said I'd contribute it. And there was and then these people were trying to 5 years down the road, litigate what was worth what 5 years ago, which is almost an impossible task. The other thing that I think is critically important, particularly I've got a lot of experience in Arizona, and one of the issues that you run into, because various states regulate things in various ways, you have to have people who are members or managers of the LLC holding these ex officio positions in a not-for-profit entity that doesn't have members or shareholders. But here's the problem. Maybe one day you decide that it's time to part ways with one of your partners, and you have a vote of the managers and the members of your LLC, and that guy's out as a manager. But he's still the sole director of your not-for-profit entity that holds the license. And all of a sudden, he has a tremendous amount of leverage over you, right? And nobody ever thought that that would happen. So you need to pay very careful attention to the regulatory aspects of how your business is organized, and how the people who are the de facto board of directors representing the owners of the business are going to be able to effect governance changes in various legal entities that you may not think you need to at the beginning. It's like you said, this is part of weathering the storm. And I was advising a business where the business was probably worth $30 million, and just getting rid of all these problems was in excess of cost in excess of $500,000, right, in legal fees, unspeakable payments to a bunch of bad actors, because the alternative was just the alternative might have been license revocation. So those are some of the things that I would be thinking about at the outset.
And that's crucial. I mean, the cost for dealing with potential disputes beforehand, as opposed to dealing with actual disputes as you're moving along, is so important. I mean, it looks like the Richter scale. It's like the costs go up dramatically when you take care of it beforehand, before anything's on the table. It's usually much less expensive. You're talking with a lawyer before the actual dispute has arisen, and it's often much more collaborative.
Even with Janet Jackham representing you, the cost of dealing with that at the outset is de minimis, and the cost of dealing with it in retrospect is gargantuan.
Janet, you're worth every penny.
You're way too sweet, Bruce. Many kisses.
Okay, thank you, Bruce. Next question for Mike. How can parties ensure that their transactions won't end up in ownership disputes?
Yes. I think, as always, proper planning is the most important thing in these types of situations. And really that begins with the people. Jeff, you're a great dancer. You like to say, none of it matters if you don't choose the right dance partner, right? And I, despite being not a great dancer, I think that's a great quote, especially in a space like cannabis, where you have so many opportunities to partner with smart people with great ideas that want to grow and they want to do something good. But as with any emerging industry, there's going to be the bad apples, right? There's always going to be the risks of running into potential partners that are either going to be unagreeable or worse, dishonest. And the worst thing that can happen to a company is to end up in a situation like that and not realize it until it's too late. So what we like to do is we view every potential transaction as a relationship from the get-go. And this process starts very early. Pretty much whenever the company starts evaluating a potential transaction, we start doing our due diligence on the company and on the team that works at the company to make sure that the company itself and the people that work there in management kind of share our values, and they're the types of people that we feel comfortable, moving forward doing business with, whether it's in a transaction or in some sort of strategic partnership. Part of that is we always like to have, once we get to a certain point, our management team meet the management team of the other party, ideally in person. And this allows everybody to get to know each other and open up this line of communication that everybody can kind of continue to foster, and it helps to build trust and help the companies know that they can work together to what should be the same end. And a lot of times in cannabis, you'll see that disputes arise not because of maliciousness on the side of either party, but just because of a lack of communication. And you see it over and over again, how important it can be to just early on and often to put in that open line of communication and continue to manage it and allow it to be there so that the companies can feel comfortable working with each other, because there's going to be hiccups. There's going to be roadblocks. I don't know that there's ever been a deal that's gone off without any sort of disagreement. It's just going to happen. And the more natural and easy the communication is, and the better the trust between the parties, the easier it'll be down the road for each of them to make sure that they're getting the information they need and to kind of protect their own interest as you move the transaction forward. Now, that's not to say that picking the right partners on its own will prevent transaction disputes, right? You still have to do the transaction. And, I feel like I'll probably echo a lot of the stuff that was said here, but what's really important there is that the parties make sure that the deal is papered up properly, the agreements are done the right way, and that all parties are aware and understand what their obligations are under the agreements. When I started in cannabis, I was introduced to the concept of a bro deal. And I found myself talking to potential deal partners, and they would ask, and I would send them back requests for things in documents, and they would come back to me and say, hey man, like, what's with all these bells and whistles? I thought this was a bro deal. I thought we trusted each other. And I always like to say that companies are always friendly with each other until they're not. Right? We're businesses. The businesses have to make their own decisions. And this is one of the reasons that it's so important to have good legal support and have, whether it's in-house counsel or outside counsel, there to help the companies make sure that they're looking at everything that they're supposed to be looking at. Now, I'm sure when the people that are listening hear me say, you got to get outside counsel involved at the beginning, all they're actually seeing is dollar signs in front of my face, right? And that's fair. It's really important to be cost conscious, and lawyers can be expensive. And this is something that companies should always discuss with their outside counsel right at the outset. I'm always talking about communication. I think that trying to set those expectations with the outside counsel of what timing's going to look like, what maybe the costs are going to look like, and just kind of how the process is going to go, will make it a lot easier to actually make it happen. And most of the time, I think companies are going to find that they'll pay less in legal fees by getting the lawyers involved at the beginning to button up all the agreements and the documents than they would by bringing them in at the end to kind of clean everything up when it's not done that way, right? And obviously it's a lot more complicated than pick the right partner, get a lawyer, profit. But at a baseline level, if you're at least doing your due diligence on your partners and making sure that you're going into business with people that align with you, and then also making sure that you have the right legal support so that your documentation is correct and that everybody understands what they're supposed to do under the agreements, you're going to be putting yourself in a much better position to handle any of those disagreements and avoid any serious disputes down the road.
That's great. Thank you. And and you made a great point. It's important to pick good partners that are trustworthy, and it's not a substitute for papering the deal. I always advise people to when someone gives you some sort of, back in my day, we did business with a handshake, which you don't hear as much anymore. But it's not that long ago that was a common phrase. I always just say, think of the unscrupulous litigator that coined that phrase. so that people wouldn't paper deals and these disputes would blow up. They're much easier to resolve when you set things down in paper, the nature of the relationship and the expectations. It makes it easier to resolve. But yes, back in the day when they did a lot of handshake deals, there were fraudsters back then too. And it was just harder to resolve the situation and much more expensive.
Yeah, and I think that sometimes there can be almost a stigma around asking parties to get more stuff papered up or get more stuff written down, because there tends to be the thought that, why is this company asking me to put all this stuff in writing? Like, what are they trying to pull? When in reality, all that putting stuff in writing does is it makes sure that both parties have everything in front of them that they're supposed to know. And it just helps people not have the misunderstandings later on down the road.
And exactly, because what sometimes people don't realize is when you're papering the transaction, you very often come into things that you didn't think about. That you realize, okay, now we have to allocate these responsibilities or assets, and when you have a competent deal attorney, they can go over those things. Well, what about a provision for this? And the parties don't even think about it because they're focusing on the things that are in their wheelhouse, the things that they think are important, and they don't necessarily focus on the things that are not. And they paper a deal, and there's a lot of things missing, but it forces them to go through that process of doing the whole deal and not half the deal and thinking that they have it all taken care of. Not only that, sometimes when we're litigating even written contracts, we have a deal, but certain key provisions weren't even negotiated, but the court is going to enforce the agreement anyway, because there's enough contribution, enough performance from either side that the court knows there's a contract. And what the court has to do is engage in this fiction of what the parties would have intended. You start to look at things like what the parties said. You start to look at things like industry standard when it wasn't contemplated at the time. And it's kind of this legal fiction that we get to the intent, even though it's known by all sides that they really didn't think about it. And you don't want to find yourself in those situations.
Exactly.
Okay, Janet?
Yes, Jeff, I was going to add a point, circling back to partners talking to each other about their own terms. If you look at current operating agreements or shareholders agreements, they might be 40 pages long now. And the average business person, particularly the people in the cannabis world who are relatively new to business, don't have a clue. I mean, and just the whole thought of having to read 40 pages is daunting. So what I like to try to do is get the partners together at the table and run through each of the provisions or the major provisions, like, gee, can you sell your interest tomorrow? Can you sell it to somebody on the street or to a family member? These are really important questions because they can go to the heart of managing the LLC or the company, the corporation. Why? Because maybe your partner doesn't want to have someone from the street be on the board with him, or a family member, a junior child, for example, being on the board or the management committee. And so, principals need to talk about that. They also need to talk about things like what happens if one of them dies or becomes disabled. Then who steps into that decedent's or disabled person's shoes? Is it a spouse? Well, geez, maybe you don't want the spouse stepping in. And that brings up community property states. You need to, if you live in a community property state and you're forming, say, an LLC or a corporation, you need to be concerned about what the laws of that state with respect to community property do. What's the result if there's a divorce or a separation? So these are, they're kind of mundane topics, but they're really, really central to the continuation of the organization and to minimize disputes among the partners.
and minimizing the disputes, Janet, is so important. All the things we're talking about, and we talked about a little bit about the cost, but there's also a cost in terms of having to endure a litigation. What you want to be doing, and what folks like Mike and the companies want to be doing, they want to be dealing with Janet. They want to be dealing with like our transactional partners, Josh Lawler and Jerry Libby, and doing deals and building things. And the more they're talking to me, because they're engaged in this litigation, the less they're building the company and growing profits. And you wonder about the opportunity cost of these executives that are distracted, that are sitting in depositions, preparing for depositions, working on strategy. They should be working on making more money for the company. And that's why it's so crucial at the early stages to set the company up right, to avoid disputes, and to make sure that if one emerges, that there's a efficient way to resolve it, because everyone's rights are well documented. Janet, and this may be a rehash, but it's a question that I saw that I just love. Why can't these people get along? Why can't everyone just get along, focus on making money, and get rid of these issues?
Oh, heck. This is a question to ask the gods. This can't be resolved by rationalizing, by psychological input, by flipping a coin, this is human beings. I thought about answering that question by maybe doing some research on the history of man and woman, the history. And what you get is that there's two diverse positions. One, it's based on our history. Two, no, it's not based on the history. It's based on the climate you're operating in. Well, we know that the cannabis industry is full of risk takers, and risk takers tend to be able to make quick decisions, maybe not necessarily well determined or thought through. And as we talked about earlier, there are all kinds of risks put upon these people's shoulders to try to comply with law when they're operating in an emerging field that doesn't have a lot of law to guide people. So I think the bottom line here is people can't get along because of greed. Mike mentioned this earlier. It's got to be, you got to be at the forefront. You got to have more money. You got to have more stores. You've got to have bigger cultivation fields, greater yields. If you're a publicly held company, you have to own up to the shareholders, to your major lenders. I mean, it goes on and on and on. And in the end, it's just business. Humans doing business. Not very profound, but I think that's what it is.
No, I think that's a huge factor, the human psychology of it. And there's a comment, you couldn't agree more, triggered by ego, greed, personality conflicts, communications issues. But sometimes, because things start off sometimes so well, and there's that honeymoon period at the beginning, when it's all just prospects and everyone's on the same page. And then when there's the incredible stress that comes down on young businesses, especially in a new industry, it can flip people who, and because you had this trust and this great feeling, and all of a sudden there's this tension, and people are kind of boxing out and trying to make sure that their interests aren't hurt. It's looked at as a tax, and the psychology of it just flips, and you're more angry than you otherwise would have been if you were with an arm's length contractor and entered into the same situation, because the trust is gone and is replaced by something that is much more defensive in nature. Bruce, and there's two questions left. We have about 11 minutes, and I want to make sure that I got to the last question here. I know we touched on this, but I wanted to see if there was anything else. What are some of the less obvious benefits of carefully documenting the business at the inception of the enterprise?
Look, I think that every business, particularly in this industry, every business that is successful will ultimately need external capital. Okay, and one of the things that I spend a fair amount of time on is helping, young-ish businesses with what's maybe their first capital raise that isn't a friends and family capital raise. And the people who provide debt and equity capital to early stage companies um, see the good, the bad, and the ugly in terms of how companies are documented, how records are kept, et cetera, et cetera, et cetera. And if you're going to a provider of capital and they say, well, we'd like to see all of your governing documents, and they're tight documents, they're well written, maybe there's a couple of things in there that they hadn't seen before, that will not make them lend you money, or it will not make them commit an equity investment, but it won't hurt, and it will make it will establish a level of trust with providers of capital that might not otherwise be easy to attain. And similarly, when it's time to sell the business, right, you can have a much more straightforward discussion about what the nature of the consideration is going to be that's going to work for everybody, what the terms with the acquirer are going to be, what indemnities are going to be in place, et cetera, et cetera, et cetera, and all of that saves a lot of time and money at the end.
Thank you, Bruce. And as a litigator, I can tell you one of the questions that often come up for young companies that are potentially getting into a litigation and bringing us on board to make sure that it gets resolved correctly and efficiently is, do we have to disclose this to potential investors? So it's not just that they like to see those documents, but they don't like to see litigation on the horizon if they're going to invest in a company and think that they're just going to be paying a guy like me to deal with the dispute.
Also very true.
And Mike, I think this might be the last one. We're running a little bit out of time, and I've got some more questions on the board. How are the considerations we've been discussing different from a public company versus a private company?
Yeah, it's a good question, Jeff. And, I don't know that I would say that the considerations are necessarily different, because I think that a lot of what we've talked about today have been generally applicable guidelines that basically any company, public or private, can use to either improve or just kind of put a check on how they do business. However, I think that at a public company, the considerations become a lot more prominent. We're an SEC reporting corporation, so we're already under a magnifying glass from a bunch of directions, whether it's our board of directors, our shareholders, prospective investors, the SEC, the list goes on. And really that just means that we always have to be careful with the way that we conduct business, the people with whom we conduct business, and how we structure our transactions, because any transaction is obviously going to have to be proposed to and approved by the board of directors. Usually details for our business dealings are going to get posted online for the public to see. And because we have these thousands of sets of eyes looking at our transactions, looking at our partnerships, looking at our financials, just becomes that much more important for us to make sure that we are putting the company's interests first and protecting the company at every juncture and setting it up for future success. And that just kind of goes back into most of the stuff that that everybody's kind of been talking about earlier. In a way, I think that being a public company has actually helped move us forward into a more structured, more deliberate way of doing business, because you have to be more accountable, not just to yourself, but obviously to the shareholders, obviously to the company as a whole, and you have a lot of eyes on what you're doing. So it forces you to really think about how are we going to structure these things, and how are we going to make sure that we're doing everything the right way.
Thank you. I think we are close to the finish line here.
Jeff, I'm back. It's Jean Sullivan. Thank you to you and your thought leader and experienced guests. Here's a few things I learned. I really liked the idea about being highly proactive at the beginning, and loved what Janet said about digging in, doing your research on either your partners, future partners, or the companies you're doing business with. I think that's really wise words. I like what you said, Bruce, about really thinking about the organization of the business up front. I think that's important, really important. I liked hearing from you, Mike, about the pace of things. It's always takes longer than you might think, and you have to be realistic. And hey, documenting, isn't that important? But I think the most important thing that I've seen through my years of experience is get good counsel up front. Don't wait till there's problems, because as we've heard, who needs arbitration and litigation and the costs attached? That is not fun, expensive, pain in the butt. You have now lost your way, and very, very painful. So I want to thank our investors and entrepreneurs who listened in today. We're proud to say that we've had over 30,000 people on our webinars throughout the last 2 years of COVID. And so we appreciate the support and participation. And we want you to keep an eye on our website where we post our events. And the next one, we've been doing these town halls focusing on various locations because things are happening. And we're going to do a town hall on Connecticut on April 28th. So that should be great. So I just want to thank Janet, Bruce, Mike, and Jeff. Thank you so much for being here today. Really appreciate your rich content that you shared today. Thank you.